Well, thank you, Jonathan, for your introduction. It's a great pleasure to be with you this morning. I guess that if we were to ask any tolerably well-educated person on the streets of Cambridge, what is the basis? What is the basis on which we human beings can live together in peace and under conditions of justice? Sooner or later, that person would mention human rights. It is, after all, the claim made in the opening preamble to the 1948 Universal Declaration of Human Rights. Human rights are the foundation of freedom, justice, and peace in the world. And this claim is one which is increasingly accepted. No decent person nowadays could be against human rights. It's also a claim which is increasingly juridified, made the subject of enforceable law. Back in 1948, human rights could be seen as an emerging code of international political morality, a code that was binding on states from the outside, as it were, having no necessary domestic legal consequences. So, for example, the emerging human rights were fully compatible with a sovereign parliament making law for the United Kingdom subject to no court. By contrast, the German constitution in 1949 was rather unusual in starting with a code of human rights enforceable before a constitutional court. And that, of course, was for entirely understandable reasons of recent history. Even then, back in 1949, in the German constitution, there was no right of individual petition. The private individual couldn't bring a case to enforce their human rights. That happened in 1966. But throughout the second half of the 20th century, Western liberal democracies steadily enhanced the status of human rights, the legal status of human rights, such that they are now, with a range of national variations, more or less equal in authority to the powers of democratically elected legislatures. Or perhaps we should put the relationship like this. Democratically legitimated legislatures operate now within the boundaries set by human rights and enforced by the judiciary. This restriction is justified because human rights represent the foundation of freedom, justice, and peace in the world. Universal Declaration. They are the conditions under which democracy does not collapse into mere majoritarianism. So, as you probably know, the United Kingdom introduced a Human Rights Act in 2000, and even democratic Republican France, now, from a couple of years ago, has a right of individual constitutional review. And if we were to go back to our tolerably well-educated person on the streets of Cambridge and ask them, why is it that human beings have human rights? What is it about human beings that produces these normative moral consequences for our political institutions? They're quite likely to answer in terms of human dignity. Again, the Universal Declaration points the way. It is, I quote, recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family, which is the foundation of freedom, justice, and peace in the world. Human beings have an intrinsic worth or value. We have dignity, and this worth or value demands mutual respect. Human rights are simply the currency of that respect. So we show our respect for the value of other human beings by not torturing them and not enslaving them, or not locking them up without a fair trial, not invading their homes or breaking up their families, by allowing them freedom to worship, to express themselves, to associate, and so on. Now, as a foundation for human rights, human dignity is particularly attractive because it appears capable of bridging different religious and ethical traditions. A Roman Catholic, a Muslim, and an agnostic humanist can all agree that human beings have dignity or worth And they can agree to differ on why exactly human beings have dignity or worth. They can disagree about the narrative about God and the world which makes best sense of this common claim. So we have here an assumption that there is a common commitment to human dignity across all traditions and civilizations, which underlies and reinforces the political role of human rights. Human dignity and human rights offer us a common point of departure, at least among all decent peoples. Any others who reject that common starting point can safely be ignored. They are beyond the pale. Now, human dignity, as the foundation of human rights, has also increasingly been juridified. It has been made legally significant by lawyers and judges. And I want us to note 3 routes by which this has happened. First of all, the human rights instruments and texts which have emerged from the interaction of nations since the Second World War are highly abstract and open-textured. Some of the rules are quite clear. So we have a simple rule, for example, that no one shall be subject to torture or degrading or inhuman treatment or punishment, Article 3 of the European Convention. And that rule is quite simple. Or we have a rule saying no one shall be subject to slavery or forced labor. All those sorts of rules require us to do is to identify the acts and social conditions which amount to torture or slavery and so on. But many other human rights establish principles which are subject to competing considerations. They need balancing. So yes, speech should be free, but not if it's obscene or defamatory or subject to commercial confidentiality or a threat to national security and so on. So where should the lines be drawn? Where exactly does the limit of free expression lie? If human rights were merely moral and aspirational, we could leave these matters vague. But as human rights are subject to litigation and enforcement, both at the international level and at the domestic level within our English legal system, these questions cannot remain open. They have to be answered concretely by judges and answered in a way which commands legitimacy. And in this process of rendering abstract rights concrete, it is inevitable that lawyers and judges reach back to what they take to be the foundation of human rights. They reach back to their understanding of human dignity. But dignity creeps into human rights adjudication by a second and more radical route as well. As human rights texts get older, they begin to show their age. Their claim to be universal and timeless is shown to be more of an aspiration, less of a realization. We can see now quite clearly the extent to which the human rights texts of the 1950s and 1960s were preoccupied with combating fascism and communism. Now, it's a familiar idea that legislative processes need to be designed to make legal change possible, but not too easy. They make legal change orderly. The same thing is true of constitutions, and that includes instances of higher law or fundamental law like human rights law. These too also need to change, just more slowly. If there is no formal process for changing your constitutional text, it happens through judicial reinterpretation instead. A constitution is inevitably a living tree. Its interpretation evolves. Now, there are people who we call interpretative originalists who want to try to stem the tide of change. And they say you must never interpret your text in any way other than the literal way. They are always fighting a losing battle. Once again, the appeal to dignity is inevitable. The form of argument is very straightforward. It's not logical, but it goes like this. Here we have a human rights text which seems to require X. It does so because at the time people thought that dignity required X. But we now understand that dignity requires Y. So let's read the text, which actually says X, as if it said Y. As I said, that's not a logical argument, but it's a good legal argument. Let me give you an example. The right to marry and found a family in Article 12 of the 1950 European Convention on Human Rights is put like this. I quote, "Men and women of marriageable age have the right to marry and to found a family according to the national laws governing the exercise of this right." In its judgment in Schalk and Kopf and Austria in 2010, the European Court of Human Rights noted that both the wording of this article and the historical context in which it was drafted meant that only a man and a woman have the right to marry under Article 12 of the European Convention. However, they also noted that in the light of social developments expressed, for example, in the European Union's Charter of Fundamental Rights of 2000, which does not refer to men and women, quotes, "The court would no longer consider that the right to marry enshrined in Article 12 must, in all circumstances, be limited to marriage between two persons of the opposite sex." However, since there was as yet no European consensus regarding same-sex marriage, it was not a requirement of the Convention that states must make the status of marriage available to same-sex couples. The court, quotes, "must not rush to substitute its own judgment." What was left unspoken was the obvious next step. If a time should come in which most European states permit same-sex marriage, then we can expect to find an equivalent right under Article 12 of the Convention, regardless of its wording and history. You see the form of the argument. The third way in which human dignity can function within human rights is as a limit to human rights. This argument has recently been put forward by the human rights scholar Christopher McCrudden. He notices that the appeal to human dignity on the part of European courts and British courts risks being particularly disadvantageous to religious people. Now, in an early case, the European Court of Human Rights held that in order for a particular religion or belief to be protected by the right to freedom of thought, conscience, and religion, it had to be, quotes, "worthy of respect in a democratic society and not incompatible with human dignity." So if your religion or belief is to be protected by the right to freedom of religion or belief, it has to be worthy of respect and not incompatible with human dignity. In other words, dignity functions here as a threshold to remove from protection of human rights beliefs and practices which are seen as fundamentally opposed to human rights values. Now, back in 1982, when the court articulated that sentence, the belief in question was the view that children should not be exposed to corporal punishment. Was this an acceptable belief to hold, that you should not corporally punish children? And it passed the test, perhaps unsurprisingly. Nowadays, of course, the views in question are more likely to be Islamic views on modesty or Christian views on sexuality. Now, the significance of this observation is that it exposes what we should have known to be true all along, which is that we do not agree on our conceptions of human dignity. Dignity does not actually function as a common moral foundation for all people, regardless of their tradition or worldview. What it is about us human beings which makes us of value and how we should treat each other as a result of that is tradition dependent on our religious or moral traditions. In our own Western European context, the two main poles of that tradition are, on the one hand, Christianity, and on the other, Enlightenment thought. And there is a tension there within our tradition. There's a tension because the Enlightenment starts with the individual human person at the center of its worldview. And if you start with the individual human person at the center of your worldview, you will be fundamentally hostile to religion. Here is Immanuel Kant, the great philosopher of the Enlightenment, in an interesting, almost throwaway comment in one of his main works, The Metaphysics of Morals. I quote, this is Kant, "Kneeling down or prostrating oneself on the ground, even to show your veneration for heavenly objects, is contrary to the dignity of humanity, as is invoking them in actual images. For you then humble yourself, not before an ideal presented to you by your own reason, but before an idol of your own making. Let me unpack that for a moment. Kant's hypothesis is this: the worship of any god other than that which is presented to your own minds as an idea of pure reason is idolatry. The worship of any god other than that which is presented to you by your own mind as a matter of pure reason, and that is the pure idea that there is a God in Kant's view, that is idolatry. Now, he didn't dare to say what he actually meant, which is that Christianity is idolatrous. Now, postmodernism can be seen as a radicalization of this Enlightenment thought, on the assumption that reason gives us no access to any God at all. So the postmodern answer to what gives us human beings value, what gives us dignity, is our capacity to make of ourselves what we will. I am authentic, I am even godlike when I am free to be the sort of person I want to be. And there are no set patterns to that process of becoming. What gives me dignity in the postmodern view is my capacity to be my own creator, to mold that plastic me. There is no divine blueprint, and there is therefore in principle no external constraint on that process of becoming. There is no limit on the use to which I could put technology in turning myself into what I wish to be. And the moment we see this, and the more we look around, we can see this postmodern conception of human dignity at work. Just some words: plastic surgery, childhood fashion, transhumanism, animal-human hybrids, family breakdown, bodily piercing, human sexuality, consumer debt, virtual reality, cannibalism, euthanasia. I am what I make of myself. And this ethical constructivism was most clearly and elegantly articulated by a political philosopher called Ronald Dworkin, one of the greatest of our 20th century, early 21st century political philosophers who passed away earlier this year. In his final grand work, Justice for Hedgehogs, Dworkin argues that our ethical responsibility to live well can be understood in terms of two principles, and I'll read them out for you. The first is a principle of self-respect. Each person must take his own life seriously. He must accept that it is a matter of importance that his life be a successful performance rather than a wasted opportunity. The second is a principle of authenticity. Each person has a special personal responsibility for identifying what counts as success in his own life. He has a personal responsibility to create that life through a coherent narrative or style that he himself endorses. Together, the two principles offer a conception of human dignity. Dignity requires self-respect and authenticity. And on this basis, an act becomes wrongful, morally wrongful, if it insults or attacks the dignity of others. Human rights are the relatively discrete components of the many ways in which the dignity of human beings can be attacked. In short, dignity is becoming a Trojan horse for the insinuation of a postmodern worldview as if it were the universal foundation of freedom, justice, and peace in the world, as if it was something no decent person could reject. And the interpretation, development, and enjoyment of human rights is becoming dependent on adherence to this ideology. I want you to notice some features of the postmodern understanding of human dignity. It is highly individualistic. The value of any relationship depends on its continuing contribution to my developing self. Commitment must always be provisional, because I would be a fool to sign my autonomy away. Postmodern dignity is also very vulnerable and defensive, precisely because there is no set pattern for human nature and human flourishing. Precisely because we must make of ourselves what we will, we can be neither right nor wrong. There is no right or wrong about it, because the universe is empty apart from you and me and what we make of ourselves. All that we can be is authentic. That presumably is why a girl guide no longer pledges to, quote, love my God, but instead to be true to myself. The classic postmodern move. So if I start criticizing you for your acts of self-creation, I am being deeply offensive. I am denying you your dignity, which resides only in your self-produced authenticity. Incitement to hatred in respect of some aspect of your identity becomes the new blasphemy, quite literally in the terms of the process of legal change. So postmodern dignity is individualistic, it's rather vulnerable, it's also abusive, because at the very least we can't treat children in this way. When it comes to children, we have to decide what is good for them, and we've got into the habit of thinking that there is no good for humankind. And so it's small wonder that childhood disintegrates into grotesque parodies of adult life. Now, in response to this development in our political and legal culture, I want to propose a thesis, I want to raise a very large problem, and I want to close with a challenge. So here's the thesis. The thesis, first of all, is not that we should abandon human rights. As I take it, human rights are really only a label for the universal requirements of political morality. The thesis is that our understanding of what human rights require needs to be grounded in a Christian conception of human dignity. And that is, first of all, deeply relational. The Reformed theologian Nicholas Wolterstorff has recently argued that the most fundamental reason that human beings have worth is because we are loved by God. That's the most basic reason why we have worth. And we can expand this in line with Jesus' great commandment. We have worth as human beings because we are loved and are capable of love, both in the horizontal plane between each other, our neighbours, and in the vertical plane in relation to God. This is not something in addition to our independent pre-existence as human beings. It's not as if we first exist and then we love. No, our relationships are not adopted as part of our conception of the good life. Like God, we are constituted by relationship. It's part of who we are, while at the same time we do not lose our personality in virtue of our existence as beings in relationship. Now, if you take that relational starting point for your conception of human dignity, you have a very large problem. And the problem is this. Insisting on a theistic component to human dignity, the vertical dimension, our relation to God, has immediate practical application in the contours of freedom of conscience. I don't think we can explain or continue to protect the right to freedom of conscience, the right that we have inherited from our political traditions, unless we locate conscience in the context of a relationship to God. So our traditional commitment to freedom of conscience depends upon a hidden theistic assumption, the assumption that conscience gives us an inescapable call of God to a life of morally responsible action. But if we insist on a theistic component to human dignity, that vertical dimension, we immediately seem to create a political problem. It seems to relegate non-theists to second-class citizenship in the ideal polity of human rights discourse. The problem gets worse. I don't think we can explain or continue to protect freedom of religion as we have inherited it from our political tradition if we detach it from the history and theology of the Christian church. Freedom of religion can be equally guaranteed to all, and is, but the underlying assumption of the detail of the law that freedom of religion encapsulates is that there is a distinct and organized part of civil society which has its own corporate identity that pursues truth, goodness, and beauty independently from the state and has a legitimacy that is higher than that of the state. All those assumptions make no sense outside of the Christian tradition. They are covertly ecclesiastical. And I hardly need mention the family. We like to think that the family is a natural form of social organization prior to the state, yet the rights to marriage, to family life, to privacy, to the home, to equality in those fields. They are all shaped by our normative conception of the family, by our sense of the ideals and the boundaries within which we are to shape our domestic life. They are formed by our view of human dignity. As Christians, we want to say that the postmodern claim to be our own creators is fundamentally idolatrous. We are created by God, and though we are created free and equal, our freedom is bounded by who we were created to be, men and women in his image. There is a pattern. That pattern is marred and spoiled in all sorts of ways. There is a fall. And because the pattern is marred and spoiled in all sorts of ways, we need a new pattern. We need to know what is original and what is defective. And God, in his love and generosity towards us, has given us such a pattern. He has come among us in human form, his Son, Jesus Christ, to give us that authentic vision of humanity. He is both the image of the invisible God and the perfect man. So human authenticity is not found in self-creation, but in being conformed to the likeness of Christ through the work of his Spirit. And this cannot be done outside of the community of spiritual formation, which is his body on earth, the church. And it cannot also be done without hope, without the hope of a future transformation in which what we will have become will at last be in perfect conformity with ultimate reality, the reality of the infinite personal creator God, three in one, perfect in love, relational for all time. So there's the challenge. As Christians who care about freedom, justice, and peace in the world, we are going to have to get a lot better at exposing the clash of ideologies that is implicit in supposedly universal human rights. And we're going to have to get better at articulating and defending an understanding of human dignity that is truly humane. Thank you.